The opinions expressed in the following program are those of the participants involved and not necessarily those of WYCC TV. The following program is an original production of WYCC PBS Chicago.
Welcome to the Chicago Bar Association's Justice and Law Weekly. I'm Dan Cotter, president of the Chicago Bar Association. On November 4th, citizens across Illinois will vote for new judges and to retain existing judges. Most people know nothing about these candidates and have no idea where to find information about their qualifications. Judicial decisions impact the lives of hundreds of people each day. As a public service, the Chicago Bar Association vets the judicial candidates and sitting judges running for retention. The CBA provides these findings to the public so they can be informed. Here to tell us how to vote smart on Election Day are Jeffrey Fink and Janine Cordero. Mr. Fink is an attorney concentrating in state and local taxation and commercial and civil litigation matters. He is also the chair of the Chicago Bar Association Judicial Evaluation Committee. Welcome, Jeff.
Thank you. Good to be here.
Janine Cordero is an attorney concentrating in special education advocacy and commercial transactions. She is a past chair of the Chicago Bar Association Judicial Evaluation Committee. Welcome, Janine.
Thank you.
And so we have an election coming up on November 4th, 2014. Most of the 400 judges serving in Cook County are elected, and voters will have the chance to vote for judges in November. Jeff, can you tell us what groups of judges will voters see on the ballot?
There are about 100 judges who are going to be on the ballot, and they fit into two groups. The first is judges who are currently sitting as judges, and they're trying to keep their job. They're trying to be retained. The other group are candidates who are running for judge who have not been elected to be judge. So there's these two different groups. And there's an important distinction on the ballot between a retention judge and a candidate who's running to be elected judge for the first time. A retention judge does not have an opponent. Under the Illinois Constitution, there's a question: should Judge X be retained? Yes or no? For those judges who have not previously been elected to be judge, they have typically an opposition. However, the way it works in Cook County is that frequently there is no opposition. The real contest is during the March primary. So there are many, indeed most, of the candidates who are running for judge for the first time have no opponent, just a couple exceptions.
And for a judge running for the first time, how many votes do they need to get to be elected?
Actually, they just need a majority vote, and that's all. However, it is different. I'm glad you asked that question. With respect to retention judges, the judges that have the yes or the no, in order to be retained, to keep their job, they need a 60% yes vote of those voting for that judge.
And 25% of voters do not complete the ballot. Why is it so important for the public to complete the ballot and select the best candidates for judge and for retention?
Well, I think obviously we want the best and brightest judges on the bench. Judges make important decisions every day that affect hundreds of people's lives. And we want judges who understand the law, who can apply the law, who have very good temperament to be on the bench, to treat litigants and the attorneys appearing before them with dignity and respect. So judges really are important people in our government and in our community, and they do a number of other jobs besides just come out in their robes and sit on the bench, which we could talk about later. But I think that a lot of people who go into the voting booth don't appreciate the significance of the judges on the ballot and what they do, and potentially that voter could appear before one of these judges. and obviously wants to get a fair hearing and be treated with respect when they do appear in court. And don't forget, we're in court for divorces, for tickets, traffic tickets, bankruptcies, mortgage foreclosures. So it's not just a criminal element. There are a number of other areas in our lives that we could potentially be in front of a judge.
If I could add on that point, of course, there's on the ballot the executive positions, the legislative positions, and the judicial positions. But following up on what Janine said, the most likely elected official that an individual is actually going to come in contact with is a judge, not the governor or the comptroller of Illinois or a representative. It's a judge who's going to be hearing, as Janine said, a divorce case, a traffic ticket, all the kinds of things that require people to come to court.
Sure.
So I just want to follow up on that too. It's very important that the voters stay and complete that ballot, because I know with over 100 names of people that they don't know in the judge category, it can be overwhelming. They could be in a hurry and say, I really don't have time for this, but it's so important that they finish voting on that ballot.
Sure. And I can see how a judge with a poor skill set could negatively affect the public, as you've just identified, both of you. However, can't the chief judge who's in charge of the circuit court fire a judge who's not performing well on the bench?
Unfortunately not. To get rid of a poor judge, the person who can hire or fire, unlike an ordinary employee, if an ordinary employee is not performing well, you're going to have a boss that's going to say, well, you know, we really don't need you around here anymore. It doesn't work that way. The person who hires and fires judges is the voters. The voters are the only ones that have the ability to fire a judge, with the rare exception of an outrageous act, criminal act. There is a judicial inquiry board that sometimes removes judges, but in the category of poorly performing judge, the only possibility of getting rid of a judge that is not adequately doing his or her job is through the voters, through a no vote on the retention election.
And how can the public inform themselves about judges that are up for election and retention, such as the 100 that are up this time?
Well, I'm going to jump in. We have at the Chicago Bar Association, there's a judicial evaluation committee, which we'll talk about. Well, it's a committee comprised of attorneys who spend a lot of hours investigating judicial candidates who are running for judge for the first time, as well as reviewing judges who are up for retention, and they are up every 6 years. And basically their findings are published in our Green Guide, which is a very lengthy guide and gives you really a lot of specifics about the qualities of that judge or that judicial candidate. And then the Chicago Bar Association also publishes a pocket guide. And I'll ask Jeff to just show the pocket guide, because it's really a double-sided one-page. And it's designed to be able to be printed out and carried into the voting booth with you as a guide. So it's a really great way to understand who these judges are and what their qualifications are.
And I see on the guide that there's some in red and the rest are in black. Can you explain the difference in the colors?
Difference in colors is that with respect to the retention judges, there is one judge in red. That's no vote. And with respect to the judges running in the elections for judge for the first time, there are not recommendeds that are in red. With respect to the retention judges, there are 73 judges running to be retained. One is in the appellate court. That's the level of court above the trial court. The circuit court, the trial court, that's one and the same. And there are 72 retention judges for the Circuit Court of Cook County. One of those judges, Thomas Flanagan, Based upon our investigation and our findings, we've concluded that he should not be retained. His number is 203. That is a no vote. He has a yes, and then there's a no, 203. 203 is in red, and we're asking the voters to vote no, vote 203, do not retain Thomas Flanagan, who's a sitting judge.
And this pocket guide and the green guide, where can the public find those?
They can be easily found and downloaded from the Chicago Bar Association website, which is chicagobar.org. And we often also publish our findings through other media outlets, such as the Chicago Tribune, and we also try to get the word out on television and in other newspapers. I think we also publish in the Defender as well. So.
Okay. And can you explain the findings? There's different findings. You mentioned that no's are not recommended. Can one of you explain the variance in findings?
Well, judges who are not recommended, as Jeff just pointed out, are either sitting judges up for retention or judicial candidates who, for one reason or another, are found lacking in their qualities. And when the Judicial Evaluation Committee receives an application from each of the sitting judges up for retention or a judicial candidate, they're thoroughly investigated by our investigations committee on the Judicial Evaluation Committee. And we receive a very thorough report about that candidate, and then they're invited in for a hearing so that we can see them personally and ask questions. And so it's really through that vetting process that we will give our different findings. If the candidate or sitting judge is lacking in a certain category that we consider important, and we can go into those in a minute, then they get a not recommended. For newly running candidates who are approaching the bench for the first time, they can be given a qualified or a highly qualified rating, and that's really to help the public distinguish between a truly excellent candidate and an excellent candidate, okay? So there are some that are just the creme de la creme, and we would really love for those people to be on the bench, obviously. And then for the sitting judges who are seeking retention, they either receive a qualified or a not recommended.
Okay. And you'd mentioned one candidate on the ballot this year that the Chicago Bar has found not recommended for retention. And do you want to remind the viewers of who that is?
It's Thomas Flanagan, and his no for retention is 203. And in particular, we found that Judge Flanagan fails to make decisions in a timely manner and does not conduct his trial call efficiently and effectively. So we're asking the voters to vote no with respect to Judge Flanagan.
And really, just to back up Jeffrey's point about efficiency in the courtroom and why that's important, I think the public doesn't appreciate unless they have to hire a lawyer. Lawyers are expensive. And a judge who doesn't move the courtroom along in a timely manner, if he starts his call late, maybe his call is supposed to be at 9:30 and he doesn't come out until 10:15, well, that's 45 minutes of lawyers' time billing their clients for waiting around. And, you know, that can be quite expensive for the client. And it's frustrating for the lawyer as well, because they're expecting to get in and get out and then get on to their next, item of business. And so that backs up their day. The other thing about...
Well, if I could add
Sure, go ahead.
On that point, it's not only frustrating for the lawyer, but for somebody who has to take, they think, 2 hours off of work. Well, if they're sitting in a courtroom for an hour and a half, they're going to miss half a day, or sometimes, if it's a really terrible situation, a whole day. So we're talking about an issue that directly affects the public, a waste of their time if a judge does not efficiently handle his courtroom call.
And along with that, not making decisions in a timely manner has the same effect in the sense that all the litigants, I think, would like a quick resolution to their issue. They don't, if you're seeking a divorce, for example, and you want it done within 6 months, well, if it takes a year and a half, it can be very, very frustrating.
And I'll add something on that point as well. In particular, in child custody matters, it is really essential for the welfare and the best interest of a child to have a decision as quickly as possible as to which parent is going to be raising the child, what the visitation is going to be, because the longer a divorce case goes on, particularly in hotly contested divorce cases, the more contention there is, and it adversely affects the children as well. So, in particular, in cases, or there's cases dealing with adoptions, there's a lot of cases in the court that affect children, and they need to be decided quickly.
Sure. And so we've talked about the green guide and the pocket guide. Can voters, when they go into the polling booths on election day or in early voting, take those with them when they go in?
Absolutely. The voters are allowed to take whatever they want in terms of paper into the, or smartphones for that matter, into the voting booth with them.
And if they're taking their smartphone, is there an application or something that they can download so that they have that information available in the booth?
They can go right to the Chicago Bar Association website, and all this information as to the individual judges, including the no vote on Thomas Flanagan, as we've discussed, all that is right on the website.
And so they can bring that in and have it on their smartphone and take it in.
I think the important thing to remember about the smartphone is if the individual can download that app prior to going into the voting place would be helpful, just because some of the voting polls are down in basements and they may have a problem getting the app to download in that environment, depending on whatever the Wi-Fi access is there. So they should do that before they actually go to the polls if possible.
That's an excellent point. And we've talked about the findings and different ratings. Are the findings of the Chicago Bar Association partisan?
Not at all.
No.
What we have is over 200 lawyers volunteering their time to do investigations, to attend hearings. We do not use politics in any way, shape, or form.
And it's also a totally voluntary basis. So these are all hours that are donated for free to do this public service on behalf of the Chicago Bar Association.
And it's also, for viewers, it's also independent from the Board of Managers and the governing body of the Chicago Bar. JEC is an independent body that we don't have any input into. So
Absolutely.
The Chicago Bar Association Judicial Evaluation Committee findings have appeared in the Green Guide and Pocket Guide, and the CBA has been reviewing judges in some fashion since 1887. We've talked some about the JEC, but can you briefly describe what the JEC is in a little more detail?
The JEC has over 200 lawyers. The bulk of the lawyers are involved in the investigation phase. Janine touched upon it a little bit. I'll expand now. A candidate has to fill out a 15 or 16-page questionnaire setting forth the entire history, everything from college to law school to a number of trials. If you're talking about a sitting judge, one of the questions asks for, set forth the name of the lawyers on both sides of the case for your last 5 trials. The bottom line is that the questionnaire has generally anywhere between 20 and 60 names with telephone numbers. Our investigators call these people and people who aren't listed in the questionnaire and try to find out what they can find out about this candidate. Is this sitting judge doing a good job? Is this candidate as a lawyer? Was he or she performing properly? The investigators write up a report And then we have hearings. The hearing members are randomly selected. People don't know who they're going to be voting on ahead of time. We invite the candidates in. We ask them questions. We ask about anything that shows up in the investigator's report that might be an issue worth pursuing. We ask them about what their current practice is. We ask them a lot of different kinds of questions. The candidate gets to sum up at the end. Then the candidate leaves. Then the hearing members, and there's about anywhere from about 12 to 20 hearing members, have a discussion, and then they vote. And it's actually a secret ballot. Each hearing member gets to say whether a candidate is not recommended or qualified or highly qualified. And I might add, because I don't think it's come out in this program so far, with respect to the retention judges, we have only two categories, qualified or not recommended. However, with respect to those candidates who are seeking to be elected judge for the first time, there's three categories: the highly qualified, the qualified, and the not recommended.
And what characteristics does the JEC look for in a judge when it's reviewing and rating the judges?
Well, there are quite a few. One of the, well, they're all important. So temperament, I touched on before, but that's very important because the public wants to be treated with dignity when they go into a courtroom. It can be very daunting. Courtrooms are large. People who are not practicing lawyers are usually not all that well acquainted with the procedures in the courtroom. And so it really helps when the judge can help, be empathetic to the litigant who appears before them, or the witness, or whomever from the public might be before them. Also, the attorneys who appear before the judge expect that they will be treated with respect and not yelled at and not cut short, but be given a fair hearing in front of the judge. Other characteristics are diligence and punctuality. We expect that the judge will show up on time at his or her call or for trial. We expect that the judge will do whatever is in his or her power to be on top of the law, to know recent changes in the law, to know the law, and to be able to apply the law. So legal ability and legal knowledge are also part of the characteristics that we look at. We also look at integrity. We obviously want to have judges on the bench who make the right decisions in their personal life as well as their professional life. So that's a very important characteristic. And we look at their professional background as well. What has their track record been? And as Jeffrey said during the investigation process, what do others think of them who have practiced with them or been on the other side of a matter with them?
And to touch on that, litigation experience for a judge is indeed a very important criteria. If someone's going to conduct a jury trial as a judge, it's really essential that that individual have conducted and tried cases as a lawyer before becoming a judge. I mean, you just need familiarity with the rules of procedure, with the rules of evidence, and those are important criteria. And back to temperament, a courtroom can be a very difficult place, and you need a judge with a calming influence on the litigants and on the lawyers at times, not some judge who's going to fly off the handle.
We've talked about the election. There's also early voting. And when is early voting?
Early voting starts October 20th and goes through November 2nd, which happens to be a Sunday. I think this is the first time that early voting, the very last day is on a Sunday. The election is on Tuesday, November 4th.
Okay. Are there other bar associations or lawyers groups that do judicial evaluations and public findings?
There are actually quite a few. The Chicago Council of Lawyers is one group. They do a very thorough job. And within their, under their auspices, there's a group called the Alliance of Bar Associations that's comprised of many different bar groups, such as the Cook County Bar Association, the Women's Bar Association, the Gay and Lesbian Bar Association, and Hispanic Lawyers Association. So there's a number, and I'm not naming all of them, but as you can expect, as you can anticipate, people running for judge or seeking retention have limited time. And so we really seek to make that process as compact as possible for these candidates. So the Alliance is great in that they can come and appear before all these bar associations in one interview. So they publish their findings as well as the Chicago Bar Association.
But if I could put in a little plug here for the Chicago Bar Association, the CBA has had involvement with the judicial ballot going back to 1880s. And the current form of what we have with the thorough investigation and the hearing, those rules were put into effect in 1976. And the American Bar Association has taken the Chicago Bar Association's rules and procedures and suggested the Chicago Bar Association's rules and procedures as a model for all state and local judicial evaluation committees across the country.
Well, Jeffrey Fink and Janine Cordero, thank you for joining us. Viewers, please vote for recommended judges. Vote no on number 203 of the ballot against retention of Judge Flanagan. Remember, you can access the Green Guide and the Pocket Guide at chicagobar.org and take them into the polls with you. I'm Dan Cotter. Thank you for watching the Chicago Bar Association's Justice and Law Weekly.
Thank you.